Hello viewers, today we will discuss the topic e-consumers. A moot question here is whether a cyber consumer in law is different from ordinary consumer or whether he is covered under the Consumer Protection Act 1986. A cyber consumer purchases goods or the hires services using the internet, whereas the ordinary computer uses traditional methods of going to the market physically, etc. Both are the consumers under the Consumer Protection Act 1986, provided they fall within the ambit of the definition of consumer, which is defined under section 2 subsection 1d of the Consumer Protection Act 1986. Consumer means any person who buys any goods for a consideration which has been paid or promised or partly paid and partly promised or under any system of deferred payment and includes any user of such goods other than the person who buys such goods for the consideration paid or promised or partly paid or partly promised or under any system of deferred payment when such use is made with the approval of such person, but does not include a person who obtains such goods for the resale or for any other commercial purpose, or hires or avails of any services for a consideration which has been paid or promised or partly paid or partly promised or under any system of deferred payment, and includes any beneficiary of such services other than the person who hires or avail of the services for the consideration paid or promised or partly paid or partly promised under any system of deferred payment when such services are availed of with the approval of the first mentioned person. Further explanation provides that for the purpose of commercial purpose does not include use by a consumer of goods bought and used by him exclusively for the purpose of earning his livelihood and by means of self-employment. Here consideration means something having monetary value in transaction of sales and purchase of goods. It means a person who obtains goods or avails services without consideration is not a consumer. Basically, consumer means anyone who purchases goods for private use or consumption at the end of the chain of production or hire services for a consideration. The definition involves the pre-existing of a completed transaction contract of a sale and purchase of goods or hiring of services. As mode of acquiring goods and availing services is not important for a person to be a consumer under this act. Therefore, whether he is purchasing goods or availing services through internet or physically going to the market, he is a consumer and a Consumer Protection Act 1986 would be applicable to such consumer. However, where he is purchasing goods or availing services either in the physical market or cyber market, he will not be covered within the ambit or purview of this act. In the case of Mira Industries versus Modern Construction, it was held that person availing services for commercial purpose is excluded from the definition of consumer. After amendment to section 2 subclause 1d, goods if purchased for commercial purposes and services attached to the good is in nature of warranty awarded, then customer could not be considered as a consumer due to the amendment to section 2 subclause 1 subclause D. Therefore, order holding complainant consumer was set aside. In the case of Bihar School Examination Board versus Suresh Prasad, according to the definition of consumer in section 2D of the Act, a person who hires or avails of any services for consideration is a consumer. The following category of service availers will not be consumers. The one is the persons who avail any service for any commercial purpose. The person who avail any service, persons who avail any service under any contract of service. A consumer is entitled to file a complaint under the Act if there is any deficiency in the service provided or rendered by the service provided. Then we will discuss goods for the commercial use. According to the explanation, commercial purpose does not include use by a consumer of goods bought and used by him exclusively for the purpose of earning his livelihood by means of self-employment. Therefore, where a person purchases goods with a view of using such goods for carrying on any activities on a large scale for the purpose earning profits, he will definitely not be consumer. But where goods are purchased by a person exclusively for the purpose of earning his livelihood by means of self-employment, he would be a consumer. For example, where a person buys a computer or a car and uses them for his own personal use, he is certainly a consumer. But a person who buys a computer or a car for consideration to be used by his employees or for using the car as a taxi, then it means the same is used for the commercial purpose. However, the commercial use is by the purchaser himself for the purpose of earning his livelihood by means of self-employment, and then such purchaser of goods would remain a consumer. Therefore, if the purchaser himself works on the computer or drives the car as a taxi himself, he would be a consumer. Then we will discuss services for commercial use. It is important to note that when goods are purchased for resale or commercial purpose, the buyer is not a consumer. However, same principle is not applicable to the services. Therefore, when a person who hires services for consideration shall be consumer, whether or not under the same or hired for any commercial purposes. In the cases of services, Consumer Protection Act does not provide for any exclusion as in the case of goods. Therefore, where a company engages the service of an architect to design its factory building, the said company shall be a consumer irrespective of the fact that the services are hired for a commercial purpose. Hence, insofar as services are concerned, all persons who hire services for a consideration are consumer, irrespective of whether they are manufacturers and traders requiring the services for a commercial purpose. Then we will discuss goods. Goods is defined in section 2 subsection 1. It means movable property of every kind other than actionable claim and money, and it includes stocks and share, growing crops, grass and things attached to or forming part of the land which are agreed to be served before sale or under the contract of sale. Then we will discuss service. Service is defined in section 2 subsection 1 clause O. It means service of any description which is made available to the potential user and includes the provision of facilitates in connection with banking, financing, insurance, transport, processing, supply of electrical or other energy, board or lodging or both, housing construction, entertainment, amusement, or the purveying of the news or other information, but does not include the rendering of any service free of charge or under a contract of personal service. A moot question is whether a service provided by a certifying authority under the Information Technology Act 2000 is covered under section 2 subsection 1 of this act. To answer this, we have to give wider interpretation to the definition of service given under section 2 subclass 1 of the CPA Act 1986. Consumer given under section 2 subclause 1 subclause D of the Consumer Protection Act 1986. Service free of charge or under a contract of personal services not included. It is significant to mention here that any service provided free of charge or under a contract of personal service is not covered within the purview of this act. Hence, countless free services which are provided through internet are not covered under this act. A contract of personal service is also excluded from the purview of the services. The Apex Court has stated the difference between the contract of service and contract for the services. A contract for the services implies a contract whereby one party undertakes to render services. For example, professional or technical for another in the performance of which he is not subject to detailed direction and control, but he exercises professional or technical skills and used his own knowledge and discretion. All service providers engaged on a professional basis and not as employees are under a contract for services. On the other hand, a contract for services implies relationship of master and servant and involves an obligation to obey orders in the work to be performed as to its mode and manner of performance. A contract of service is excluded from the definition of service. Therefore, if an employee does not perform his duties properly, he cannot be forced to serve his employer under the Consumer Protection Act because his duties as an employee are not covered within the ambit of service under the consumer law. Then we will discuss the term defect, which is defined in section 2 subclause 1 subclause F. It means a fault, imperfection or shortcoming in the quality, quantity, potency, purity or standard which is required to be maintained by or under any law for the time being in force or under any contract, express or employed as is claimed by the trader in any manner whatsoever in relation to any goods. Then we will discuss deficiency in services. Section 2 subclause 1 subclause G defines. It means any default, imperfection, shortcoming or inadequacy in the quality, nature and manner of performance which is required to be maintained by or under any law for time being in force has been undertaken to be performed by a person in pursuance of a contract or otherwise in relation to any service. In the case of Balkishan versus Om Prakash, the total lease was paid by the petitioner in advance, but the electricity dues were not deposited by the petitioner. Connection was disconnected. Respondent could not draw water due to non-supply of electricity. Crops were badly damaged. Land was taken on the lease only because of the electric tube installed on it. Petitioner was liable to get tube in the working order to ensure that water is made available for the irrigation purposes. Without there being condition in agreement, the electricity charges were to be paid by the respondent. The petitioner could not shift burden of payment of electricity on the respondent. Then we will discuss the Consumer Protection Council. Significantly, to protect and promote the interest of the consumers, the Act provides the following three councils. The one is the Central Consumer Protection Council, another one is the State Consumer Protection Council, and the third one is the District Consumer Protection Council. First, we will discuss the provision of the Central Consumer Protection Council. What is the composition of the Central Consumer Protection Council is defined in section 4 of this particular Act. The central government is empowered to establish by notification a council to be known as the Central Consumer Protection Council. Accordingly, the Central Consumer Council was established, which consists of the following members. The one is the ministers in charge of the consumer affairs in the central government, who shall be its chairman. Another one is such number of other officials or non-official members representing such interest as may be prescribed. Then we will discuss procedures for the meeting of the Central Council, which is defined in section 5 of the CPA Act. The Central Council meets as and when necessary, but at least one meeting of the Council is to be held in every year. Further, it meets such time and place as the chairman may think fit and observes such procedure as is prescribed. Then we will discuss the objects of the Central Council, which is defined in section 6. The object of the Central Councils are to be promote and protect the rights of the consumer, such as the one is the right to be protected against the marketing of goods and services which are hazardous to the life and property. Then the right to be informed about quality, quantity, potency, purity, standard, price of goods or services as the case may be, so as to protect the consumer against unfair trade practices. The right to be assured wherever possible access to a variety of goods and services at competitive prices. The right to be heard and to be assured that consumers' interest will receive due consideration at appropriate fora. Then the right to seek redressal against unfair trade practices or restrictive trade practices or exploitation of the consumer. Then the right to consumer education. Then we will discuss the State Consumer Protection Council. First we will discuss its composition, which is defined in section 7. The state government is empowered to establish a council known as the State Consumer Protection Council. This council consists of the following members. The one is again the minister in charge of the consumer affair in the state government, who shall be its chairman. Again, such number of other officials or non-official members representing such interest as may be prescribed by the state government. Then such number of other officials or non-official members not exceeding 10 as may be nominated by the central government. Then we will discuss the meeting of the State Council. The State Council meets as and when necessary, but not less than 2 meetings shall be held every year. However, it meets at such time and place as the chairman thinks fit and shall observe such procedure as prescribed by the state government. Then object of the State Council. The very object of every state councils are to promote and protect within the states the right of the consumer, such as the right to be protected against the marketing of goods and services which are hazardous to the life and property, and right to be informed about quality, quantity, potency, purity, standard and price of good or services as the case may be, so as to protect the consumer against unfair trade practices. Then the right to be assured wherever possible access to the variety of goods and services at the competitive prices. The right to be heard and to be assured that consumers' interest will receive due consideration at appropriate fora. Then the right to seek redressal against unfair trade practices or restrictive trade practices or exploitation of the consumer. Then the right to consumer education. The last we will discuss the District Consumer Protection Council, which is defined in the section 8. The state government is also empowered to establish for every district by notification a council to be known as a District Consumer Protection Council. The District Consumer Protection Council consists of the following members. One is the collector of the district by whatever name called, who shall be its chairman. Then such number of other officials and non-official members representing such interest as may be prescribed by the state governments. Meeting of the district council. The district council meets as and when necessary, but not less than 2 meetings shall be held every year at such time and place within the district as the chairman may think fit, and observe such procedure as prescribed by the state governments. Then we will discuss the object of the district council, which is defined in section 8b. The object of every district councils are to promote and protect within the district following rights of the consumer. The one is right to be protected against the marketing of goods and services which are hazards to the life and property. The right to be informed about the quality, quantity, potency, purity, standard and price of goods or services as the case may be, so as to protect the consumer against unfair trade practices. Then the right to be assured wherever possible access to a variety of goods and services at competitive price. Then the right to be heard and be assured that consumers' interest will receive due consideration at appropriate fora. The right to seek redressal against unfair trade practices or restrictive trade practices or exploitation of consumer. Then right to consumer education. Then we will discuss Consumer Dispute Redressal Agencies, which is defined in section 9 of the CPA Act. The Act also provides for the establishment of the following consumer redressable agency. The very first is a Consumer Disputes Redressable Form to be known as the district form, to be established by the state government in each district of the state by notification. However, the state government, if it deems fit, establish more than one district form in a district. A Consumer Dispute Redressal Commission to be known as the State Commission to be established by the state government in the state by notification. Then a National Consumer Dispute Redressal Commission to be established by the central government by notification. Then we will discuss district form. Composition of the district form, which is defined in section 10. Each district form consists of the following member: a person who is or has been or is qualified to be a district judge, who shall be its president. Then 2 other members, one of whom shall be woman, who must be qualified to act as a member of district forum. Then qualifications of the member of district form. The members of the district form must have the following qualification. The very first is he must not be less than 35 years of age. He must possess a bachelor degree from recognized university. He must be a person of ability, integrity and standing and have adequate knowledge in dealing with the problems relating to the economics, law, commerce, accountancy, industry, public affairs or the administration. Then we will discuss jurisdiction of the district form, which is defined in section 11. The district form has following two types of original jurisdiction. The one is pecuniary jurisdiction, another one is territorial jurisdiction. District form has pecuniary jurisdiction to entertain complaints where the value of the goods of services and compensation, if any claim, does not exceed rupees 20 lakh rupees. Then the territorial jurisdiction, and complaint is to be initiated in a district form within the local limit of whose jurisdiction the opposite party or each of the opposite parties where there are more than one at the time of institution of the complaint actually and voluntarily resides or carries on a business or has a branch office or personally works for gain, or any of the opposite parties where there are more than one at the time of institution of the complaint actually and voluntarily resides or carries on business or has a branch of office or personally works for a gain, provided that in such case either the permission of the district form is given or the opposite parties who do not reside or carry on any business or have a branch office or personally work for the gain, as the case may be, acquaints in such institution, or the cause of action wholly or in part arises. Then we will discuss appeal, which is defined in section 15. Any person aggrieved by any order made by the district form may file an appeal against such order to the State Commission within the period of 30 days from the date of the order. Then we will discuss the State Commission, which is defined in section 16. Composition of the State Commission. Each State Commission consists of a person who is or has been a judge of a high court appointed by the state government, who shall be its president. However, no appointment under this clause shall be made except after consultation with the Chief Justice of the High Court. Not less than 2 and not more than such number of members as may be prescribed, and one of whom shall be women. Then we will discuss qualifications of the member of State Commission. The member of State Commission must have the following qualification. The very first is again, he must not be less than 35 years of age. He must possess a bachelor degree from recognized university. He must be a person of ability, integrity and standing and have adequate knowledge in the dealing with the problems relating to economics, law, commerce, accountancy, industry, public affairs or the administration. Then we will discuss jurisdiction of State Commission. Section 17 define again pecuniary and territorial jurisdiction. State Commission has to entertain complaints where the value of the goods or services and the compensation, if any, claims exceed rupees 20 lakh but does not exceed rupees 1 crore. The territorial jurisdiction, a complaint to be instituted in a State Commission within the local limit of whose jurisdiction the opposite party or each of the opposite parties where there are more than one at the time of institution of the complaint actually and voluntarily resides or carry the business or has a branch office or personally works for a gain, or any of the opposite party where there are more than one at the time of the institution of the complaint actually and voluntarily resides or carry on business or has a branch office or personally works for a gain, provided that in such case either the permission of the district form is given or the opposite parties who do not reside or carry on business or have a branch office or personally work for the gain, as the case may be in acquiescence of such institution. The cause of action wholly or in part arises. The National Commission is defined in section 20. The composition and qualification of National Commission. The National Commission consists of judge of the Supreme Court to be appointed by the central government, who shall be its president. Similar kind of qualifications are there for the National Commission, which are for the State Commission. Pecuniary jurisdiction can be exceed 1 crore in case of pecuniary jurisdiction of the National Commission. In end, we can say cyber consumer in law is different from ordinary consumer. District form, State Commission and National Commission play a different role for resolving disputes relating to e-consumers. Thank you viewers for watching this program.